Welcome to Unit 12. In this unit, we're going to discuss the remedies for breach. In this specific subunit, we're going to discuss the basic concepts. In this unit, we're going to discuss the following topics. We're going to discuss basic concepts of remedies. We're going to discuss general damages. Then we're going to discuss consequential and incidental damages. We'll explore the mitigation of damages and liquidated damages. We'll talk about the UCC approach to damages, and then we'll talk about equitable remedies. All right, let's explore some basic concepts. Let's explore the difference between legal remedies and equitable remedies. Let's talk about what liquidated damages are, and let's talk about what the duty to mitigate damages is. So first, legal remedies versus equitable remedies. So a legal remedy just means money damages. This is where the court requires the breaching party to pay money damages to the non-breaching party because of her breach. Equitable remedies is where a court forces a party to perform her obligations under a contract. Or, alternatively, a court may prevent a party from performing someplace else under another contract. We'll talk about that later. The preferred remedy for contract breach is legal remedies, money damages. We only give equitable remedies in extreme circumstances. Let's talk about liquidated damages. Liquidated damages, just damages, money damages the parties agree to in their contract before anyone has breached. So as an example, if I hire you to be a contractor to finish a project for me, and I say, for every day late, you must pay me $1,000. That's in the contract, and we call those liquidated damages. Finally, let's talk about the duty to mitigate damages. So imagine that you're a breaching party, I'm the non-breaching party, so I'm entitled to money damages, but the damages that I am entitled to will be reduced by the injury I could have prevented to myself. So the whole idea is that if you breach your contract with me, I have to go out and find substitute performance so that I can be made whole, so that someone will perform for me. I can't just sit there and say, okay, you have breached this contract, and now all these problems that I have, you are responsible for. If I could have avoided those problems by finding substitute performance, finding someone else to do the work for me, then I have not mitigated my damages. And any damages that I'm entitled to receive from you will be reduced by the injury I could have prevented by finding substitute performance. All right, continuing on with some more basic concepts, let's talk about punitive damages. Let's talk about nominal damages, and let's talk about attorney's fees and court costs. So, punitive damages, right? Punitive damages are damages that a court will impose on a wrongdoer to punish that party. It's not intended to compensate the other party, right? It's intended to punish the wrongdoer. You will see this in your torts class when someone causes injury to someone else because of their reckless or intentional conduct. The court might impose punitive damages on the wrongdoer. We do not see this in contract. Naturally, we might see it in a case of fraud, but fraud is really a tort, and the court would be imposing punitive damages on the tort of fraud. Nominal damages. Nominal damages are typically $1. A court will award the non-breaching party, the aggrieved party, $1, saying there was a breach, the other party breached the contract, but you have not suffered any real injury. Finally, attorney's fees and costs. If you're a breaching party, I'm the aggrieved party, I'm the non-breaching party, I sue you for breach, I have to hire a lawyer, I have court costs. When I recover from you, the money damages that you pay me will not include my attorney's fees and will not include court costs, unless beforehand in our contract we agree that the breaching party will be responsible for attorney's fees and court costs. So once again, the breaching party is not responsible for the non-breaching party's attorney's fees and court costs unless beforehand they had specifically agreed so in their contract. All right, let's talk about the difference between expectancy and expectation damages versus reliance damages versus restitution. Okay? The key here is that contract damages, legal damages for breach of contract, we try to give expectancy damages, and that's the first one. So what are expectancy damages? Well, the breaching party has to put the non-breaching party, the aggrieved party, in as good a position she would have been had the contract been performed. Right? That is the goal of contract damages, putting the aggrieved party in as good a position she would have been had the contract been performed. And we use a dollar amount to accomplish that. Now, what are reliance damages? Well, reliance damages are typically the damages that a victim will get in a tort case. What are reliance damages? Well, we put the aggrieved party in as good a position she was before the transaction, before the contract. So you see the difference between expectation damages and reliance damages. Expectation damages, we put the party in as good a position she would have been had the contract been performed. It's forward-looking. Reliance damages, we put her in as good a position she was before the transaction. You see how this makes a little bit more sense for tort, right? You injure me, you are required to put me in as good a position I was before you injured me. All right, finally, there's restitution. And restitution focuses on the breaching party or the wrongdoer giving up any benefit she has received. Once again, contract damages, we focus on giving the expectation damages if we can. Sometimes it's hard to prove. Sometimes it's hard to show where the party would have been, where the aggrieved party would have been had the contract been performed. But our goal is to do that. All right, here's an example of expectation damages. It's a very famous case. So a patient goes to a doctor with a burned hand, and the doctor says, I promise to make your hand as good as new. Doctor operates, grafts some skin from another part of the patient's body, puts it on his hand. After the operation, the patient still has a burned hand, but now it's hairy also. So the patient has a hairy and burned hand after the operation. So if we sue the doctor under contract, it's expectation damages. So what are our expectation damages? Well, it's difficult to assign a dollar amount to this, but this is the formula. We need to put the aggrieved party here, the patient, in as good a position she would have been or he would have been had the contract been performed. So it's where it's the promised performance minus the actual performance. That's kind of the formula. So in our fact pattern, where would the patient have been had the doctor performed the contract as promised? Well, the patient would have had a hand as good as new. How did the doctor actually perform? The doctor gave the patient a hand that was burned and hairy. So the difference is the difference between, and we have to assign quantities, like money quantities to this, which is very difficult, but at least getting the formula down, we can do it. So it's the difference between a hand as good as new, what was promised, versus a hairy and burned hand, what was actually delivered. If we sue the doctor in tort, well, we remember our tort remedies are reliance remedies. So the idea is to put the victim, here the patient, in the position she was before performance of the contract, before the parties entered into the contract. So the patient in this case had a burned hand. What did the patient wind up with? A hairy and burned hand. So what are the reliance damages? Well, it's the money equivalent of the difference between a hairy and burned hand minus a burned hand.